Hello, everyone. Thanks for joining us today for our Pivot Plan webinar number 3. I'm Alex Anglum. I'm going to introduce our panelists very shortly and get into a little discussion of what's going on. If you haven't been with us before, this is the third in a series of our Pivot Plan webinars, which really, although they weren't designated as a Pivot Plan, really started around the beginning of the COVID-19 crisis, where we organized a series of webinars to help our clients and friends deal as best they can with the new reality from lockdown, shutdown, Payroll Protection Act, return to work issues, physical site issues. We recently had an engineering expert tell a lot of our folks some very important and useful information about making sure that their physical facilities are ready for people to return to work and not contribute to the spread of the disease. And today's webinar is the third in the series of pivot plans where we're going to talk about some important cybersecurity and e-discovery issues that are affected by COVID-19. Let me just say that the overall approach that we've taken with the pivot plan is certainly to give our listeners and participants in the webinar actionable information that they can use to adjust and cope with the situation that we're all facing right now. But more than that, what we really hope to look at is as a positive, so that not only can you return to normal operations, but that hopefully that this will be a springboard for even greater success in the future. With that in mind, let's introduce a little bit our law firm and the people who will be joining us today. First of all, as I said, I'm Alex Anglum. I'm going to be joined today by my colleague, Alicia Chan, who's one of our lawyers at Santa Massimo Davis. Our law firm is a boutique business firm that services mid-cap clients, primarily with our outside general counsel offering. And our approach in the outside general counsel offering is to serve as our client's outside law department. So, for example, we all know large organizations, very large companies, have dedicated in-house legal staff. They're large enough to have a group of different lawyers who can tackle a wide variety of different issues. We aim our offering at companies that are just under that level to maybe down to the level of startups, where they aren't large enough to have a team. Maybe they could have one in-house lawyer, but we bring them that team and provide them with a virtual law department, often on a fixed fee basis, so that we duplicate the service of the in-house law department in a Fortune 500 company, but oriented towards a mid-cap company, and of course with a cost structure that they find favorable and gives them budget certainty. We have been joined in all three of our pivot plan webinars by not only our own lawyers, but outside experts. And, to do that, that's been a way that we've brought both practical and legal factors together in the pivot plan so that businesses can get information that comes not just from a legal perspective, but also from other subject matter experts who can bring a lot of value to you and again, provide those who are listening today with actionable information that they can use to develop their business planning and create a springboard for dealing with this crisis in the best way possible. So as I said, today we'll be hearing from Alicia Chan. One of our attorneys is going to speak in some detail about e-discovery and how you ought to be reconsidering and planning for e-discovery impacts of the COVID-19 crisis. And we're also joined by Harry Sirolowitz from Atlantic Tomorrow's office. And at this point, as I introduce Harry, I'm just going to stop sharing my screen because Harry has some different slides that he's going to move to. If you bear with, I think I apologize. I may have hit the. All right, so let me talk about Harry. Harry Sirolowitz has been in the IT industry since 1983, and he owned and managed an IT services firm. for 30 years, focused on IT security for customers in the banking, insurance, and healthcare industries. In 2017, he merged his company with Atlantic Tomorrow's office, where he continues to provide security advisory services to Atlantic's customers in his role as manager of customer security and guidance. Atlantic Tomorrow's office has a long-standing relationship with our law firm, and we have several clients in common who are both clients of our firm and customers of Atlantic. And from that, we've cooperated over a long period of time. Harry works closely with banks' boards of directors, IT steering committees, assisting with FDIC audit preparation and providing guidance with various regulatory security compliance requirements. He's a frequent speaker. He's presented to groups of lawyers and bankers, school board members, and others. He's a true expert in this subject, and we're very happy to have him with us today. And with that, I'd like to turn it over to Harry.
Okay, well, thank you very much, Alex. Appreciate it. Hopefully everybody can see my screen and hear me well. And good afternoon, everybody, and welcome to yet another webinar that's out there. But we think it's very, very important for having these conversations frequently, just as a reminder and a reinforcement for everybody to understand what's going on in the security world and this war that continues to rage on. And as participants, both on the attacking side and the defense side, which is what we're on, we have to understand, everybody's trying to up their game and evolve their tactics. So as we go through this, I really just hope everybody can get actionable takeaways and be a catalyst for ongoing conversations in your organizations. And, as we go through this, obviously write questions down and we'll be happy to answer them as we go through it. So really, in light of COVID and the current world events that keep coming up, things we can't control, as Alex said, there's a lot of times a silver lining in these experiences that we have and what we've been forced into, and it helps us to better prepare for the future and possibly continue to enhance and explore new ways to make our organizations more competitive, efficient, and secure. Hopefully, again, this conversation will help people and aid them in making more informed and objective decisions about reimagining and redefining what the future remote workforce looks like from an operational and as well from a security perspective. And to us, why these security conversations matter is that we realize that it took our customers years to build it, but yet one breach can destroy it overnight, and we've seen it happen, unfortunately. So we realize that it really matters to you personally, to your businesses, to your employees, your families, and of course to your customers. And we also know that it's important to note that the cost of not implementing very basic security measures is nothing compared to the cost of a breach when you look at the repercussions of the financial, legal, reputational, and of course loss of customers that can result. And of course, everybody's mission is really to continue to find ways to protect our customers. So look, folks, as we know, we've had significant security challenges prior to COVID, and now it's really been magnified that everybody was instantly forced into transforming their workforce into a work from home model. And now, because of that, the security concerns become more critical than ever. And the things that happened was that we know that existing infrastructures, networks, security, processes, people weren't informed enough and designed to really support the work from home environment. And basically, we know there are a lot of times what we've seen is insufficient main office connectivity and resources to support a remote workforce coming in at once. Of course, the home security, the connectivity, it's pretty much insufficient to have people securely connect to their environments. Of course, there was no real transition plan. We didn't have time. It was like an instantaneous thing that had happened. And again, we talked about the non-existing and ineffective security that was not really in place to protect remote users and therefore our networks and our data. So the new network perimeter and the security perimeter now is our employees' homes. And being so distributed, it's very, very difficult to protect that. So again, prior to COVID, we certainly knew that the cyber attacks were getting more serious even before this. But there is an overwhelming consensus from security professionals that we are seeing an exponential increase in the volume, frequency, sophistication of malicious emails. And while the danger may not be hitting us in the face and may not be clear, it's always present. So I'm also going to talk about some of the stats and facts because there's a lot of truth and insight in the numbers, and they truly provide a justification for the actions to help mitigate risks. And we hope people can take some of that away with you today. So in starting out, we have to understand that 1 in 4 organizations will experience a data breach. Severity, we're not sure about, but it happens frequently. And McAfee, a very large security firm, just analyzed cloud usage between January and April. And that survey indicated the increase in threat events in the cloud accounts was increasing at 1,300% or more across various industries. They're incredible numbers. And it's impacting every size organization, not just large ones that we hear about on the news, but also as the small and medium-sized businesses in every industry. As a matter of fact, almost half of all the attacks are targeting small and medium businesses. More disturbing is that about 60% of businesses will go out of business within 6 months after an attack. So these are a couple of foundational things I like to make sure people understand as a foundation to security, how you think about it. Number one, if there is a vulnerability, it will be exploited at some point. And also to know that everything has a vulnerability. So look at number one again. And that's why all the manufacturers continually upgrade and patch their systems and software all the time. We also know that people are way too trusting when they should not be. And that's one of the biggest problems that we have to deal with. And we'll talk about this. Additionally, we know that innovation, new technology, and changes creates complexity and vulnerabilities. And when we moved from COVID to the home environment, that's one of those issues which created these vulnerabilities. So security needs to be a conversation in advance of making the changes, not after the fact. You can't tack security on and have it be done successfully after it's already been done. And of course, security culture always starts at the top by the owners, executives, stakeholders to understand, to commit to, and to invest in relevant technology to protect their organizations and their customers. And look, we know we're in this ongoing arms race, and it really creates a cybersecurity fatigue. We're constantly hearing about it, trying to identify the threats and then implementing effective, and comprehensive, and affordable security, but without impacting users' productivity can be very complicated, can be expensive, and it takes significant expertise and resources. And while I can't really encapsulate the conversation to include all of these areas that you're seeing on the screen, we're going to really focus on 3 basic areas right now. And the areas we're going to focus on are things that are easy to address, and they're affordable actions that should be taken today by everybody. We're going to talk about the challenges with the influx of email, how we look at remote access to enable operations, but also to be done securely. And of course, how we do that with proper identity or access and permissions to our users that are attaching to our network. From an email perspective, you have to understand the magnitude of this is that there's over 300 billion emails that are sent per day. That's the estimate. More disturbing is that about 1 million pieces of new malware, literally, that are being released every day. It's a deadly combination when it comes to businesses. And that's why we know that traditional security solutions and methods like legacy antivirus and malware systems and firewalls are just simply not enough. We really need to look at next generation security and training because it's required. And again, I'll mention it a few times, but over 90% of all breaches start from an email. So we know that criminals have been exploiting the COVID and work from home situation by increasing the way they're weaponizing emails these days. The rates are going up, and they're of course targeting users because users are the #1 area where they can make attacks successful. It's also a consensus that these attacks are basically, the malicious emails are going up by 600% just during this COVID environment right now. And how they're doing it, and we pretty much know a lot of these things already, but we know that phishing and spear phishing is huge. It's tricking employees to divulge sensitive information or to take an action. And I've had many conversations with many clients over the last few months, and it's amazing how many of the employees are really submitting information where they shouldn't, or going out and buying gift cards and sending them to bad actors. It really is amazing. And 1 in 25 emails are malicious in terms of having phishing type of intent to them. Of course, we know that there's malicious links and malicious attachments, all which are disguised, and it's hard for people who are not trained to click on things and identify what is malicious. And with attachments, it's the ransomware that comes from it. And one thing I like to mention is people need to be very aware right now, especially from Microsoft documents like Word documents and Excel documents. More and more of them are containing malicious code and malicious files in them. So you need to know who they're being sent from. The business email compromise, and that's where a lot of the biggest fraud cases have come from, where the actual email system gets taken over. The bad actors are watching the activity, watching what's going on, watching the people, and then they do malicious transfers and fraud of wire transfers and paying of large invoices. We'll talk about that a little bit as well. And of course, in the work from home, as I mentioned, people are distracted because people are the weakest link, and we're certainly going to work on this. So some of the facts around that is we do know that ransomware now hits a new company every 14 seconds. And it's very damaging because it creates downtime and loss of information. Equally important, though, is that we know that most malicious threats sit on an individual's network for 200 days or more before it detonates itself and does its damage. They're watching and getting ideas of what they can do for more intense damage. So basically, a relevant term right now is your network may be asymptomatic. It may be infected, you just don't know it unless you're really looking at it and monitoring it. And of course, as I mentioned, the phishing is a major issue we're going to deal with. You know, we talk about the frequency of ransomware and the phishing attacks that are causing business most harm. And if we go back to just what happened recently with the New York law firm that had their data stolen, and then their current systems were encrypted, where they then claimed they had Donald Trump's information and other celebrities. That's what we're finding more and more of. And during this COVID-19, these cases have more than doubled. Now the losses are in some cases much higher than what we see here, $100,000 to $500,000. And again, I'll say it again because this is my common thing here, is that over 90% of all the attacks start with an email. So knowing that and acknowledging that people are the weakest link, you know, there are things that we can do to take action today and fight this. The number one thing that you can do is to continue to educate and train users as to what to look for and what to do or what not to do. We really need to focus on changing their habits. And we need to do this not by just telling people, but by having an ongoing, frequent, and regular campaign of testing their current habits of clicking on things and not, and having them make these changes. We also need to secure our email accounts better use of passwords and MFA, which is multi-factor authentication, which I'll get into in a few minutes. And then, of course, you know, as I mentioned earlier, we want to deploy next generation email security, which will help us to minimize all that email and prevent it from entering our inboxes from our users. That will significantly help the risk of people clicking. And we can also, which I'll talk about more, filter inbound and outbound traffic and maybe prevent ransomware from even detonating itself. So the training can be something which in a lot of these programs involve is just showing people what to look for. There's so many signs in an email of whether it's where they're coming from, the date and time the email's being sent, the content, knowing where to look at links. But again, these things need to be done on a regular basis because these type of emails and the phishing emails continually change based upon world events. Again, the bad guys know how to weaponize every event that's out there. Additionally, when you look at ransomware, you know, ransomware basically arrives in an email and people click on it. And typically what happens, it calls out to the internet to get an encryption key and then comes out and encrypts your data and basically game over, you're done. So we can actually stop this callback, you know, by very simple means or prevent it many times and, you know, maybe prevent this ransomware from even affecting the user, but these things that have to be put in place in advance. So, and it's also not just email. It's also people need to be aware of the cloud services like Dropbox, your Office 365 and OneDrive accounts, Google Apps. They also contain very nefarious type of documents that people can download as well. So it's all these social media habits that need to be changed. Again, goal is to see if your people would recognize a cyber attack. And our goal is to make sure we create human firewalls out of our employees to make them be able to identify these risks and stop them. So that's on the email side. On the remote access side, which we're all facing right now, these email threats, especially in this environment, present a really unique challenge regardless of where the users are and where your data resides. We already know that people are the weakest link because we've talked about that already. Now we put people at home and there are a lot more additional risks. There's no control or physical oversight to their activities because there's a lot of distractions. There's poor or insecure internet connections and vulnerable home Wi-Fi, which we need to be concerned about. There's vulnerable personal computers and mobile devices. They're not patched. They have ineffective antivirus. So they're very high risk to infection or being compromised. And then when they connect to your corporate network, they can expose you with whatever the virus is, or the nefarious actor getting into it remotely. Of course, people at home have very unsafe social media habits, and sometimes they share them with other family members, which can be a big problem as well. And of course, we want to control and validate user access to our corporate systems. So the number one way we want to deal with this in the very front of it is going to be is we need to find ways and methods to validate that every user that's connecting to our network are who they say they are and is authorized to connect. And the fact here is that 81% of all hacking related breaches come from either stolen or weak passwords. So goal number one is everybody should immediately be using some type of multi-factor authentication, which is what you use at your bank when you get the code on your phone. You should be using it on your remote connections, on your VPNs, your network access, and of course on your email. You'll be 99% less likely to be compromised when you use MFA. And there's compelling reasons to do it, and there's no reasons or excuses not to. It's simple to do. The right MFA solution can be integrated into multiple applications, not just your network and your VPNs and your email. It's inexpensive to implement. It's very transparent to users. So all they need to do is basically click accept on their phone or maybe enter a code. And also in many industries, this is a regulatory requirement. And you may find your customers are going to require it if they don't already. Knowing the status of the devices, another critical thing we talked about, when possible, if it's possible, users should be using business-owned computers that have managed security solutions on them and that are locked down so you can prevent unauthorized software from being installed. And that includes things like ransomware installing itself because a user is going in under their admin credentials. Home computers, if they're using that, they got to be protected. You need high quality enterprise grade antivirus. You got to make sure the systems are patched. And if all possible, we hope that maybe they cannot be shared with the rest of the family members, or at a minimum, don't share the same logins and passwords to your employees with the rest of the family. We need to confirm that, as people work from home, their internet and Wi-Fi connections are secure, whether it's firewalls or other devices, routers, and of course, we mentioned the password side of it. And you want to make sure, of course, that their internet connections are stable as people need to do more work from home with some pretty heavy duty applications like AutoCAD or some other very resource intensive applications. Then we get to the passwords and permissions part of it. These are critical. Password policies and procedures, they have to be done. They may be inconvenient, many people think, but they're absolutely necessary. So in this realm, password length is more important than complexity. If you can get over 17 or 18 characters, that's great. To make it easier for our users, they can use cognitive passphrases like, I like rainy beaches on rainy nights. It's impossible for computers to crack such a long password, but people can remember things like that. And you need to change passwords frequently as possible. And we know that could be a challenge, so maybe consider a password manager app for the individuals or from the corporate side. We always talk about not sharing or using the same passwords for multiple systems, sites, or applications. Again, multi-factor authentication may be able to help with that. We talk about locking down these PCs, again, for normal use. And what I mean by that is when you log into your computer as an admin, if you download ransomware and click on it, it can install itself. If you log in with a limited use account, it won't have the rights to install itself. Very simple things to do that doesn't even cost any money. And of course, on your network, you need privileged access to make sure that the right people have the right access to the right data and applications. So we don't want anybody to get to the wrong place when they shouldn't be. And of course, remember that, like the law firm in New York found out that if you lose all your credentials and you lose data because people are exfiltrating it, it's going to end up on the dark web and it's going to get sold. So you may want to monitor the dark web as well to get actionable information. If you see your stuff out there, you can take action against that and changing your passwords possibly and preventing an attack. So, let's talk really about, again, summarizing how we can really protect ourselves. The first thing you have to do is, remember that the attacker only needs to be successful once, but you need to be successful all the time. And complete safety is not assumed to be possible. So with that being said, you need to really understand your vulnerabilities and risk. Where's your sensitive data? What is your sensitive data? And if something were to happen, what's going to be the cost of that breach? And you need to balance that with cost and people's productivity, but that's where you need to start. And it's inevitable that any enterprise can and will probably be breached at some time. So kind of in closing, as a summary, what we just talked about, and we can send this to you for whoever may want this. User education is critical. It's easy to do, and it should be done day one. We need to teach people what to do, what not to do. Multi-factor authentication, easy to do, inexpensive, and should be done to protect the organization. Managing privileges and passwords, it just has to be addressed in the proper way. The home and mobile networking, we need to train our staff, make sure our devices are protected on the perimeter, and make sure that they're being used properly at home. The next generation email security, let's minimize the risk of bad emails coming to you because there's so many of them. Properly securing and secure configurations to all our devices. And that can also include, the network, the end user devices, and also possibly even encrypting sensitive data when possible. There certainly should be some policies and incident management planning to go on. It's a critical piece as well, and make sure the right people know about it. And I have to say it, but backup, and backup. You need to be sure that you can back your data up frequently and make sure you can recover fast. And getting cyber risk insurance is also very, very critical. So on backup real quick, just two things you need to ask yourself. How much data can you really afford to lose? Which means, how frequently does your backup run? And how long can you afford to be down? Or how fast can you recover? That will drive your decision on your backup solution. So where do you go from here? Identify your critical assets, train your employees, protect your devices, keep everything up to date, get cybersecurity policies in place for all your employees, make sure they know about it, and back up frequently. And with that said, I'd like to turn it back over to Alex and the team.
Oh, thank you, Harry. Appreciate that. With that, I'm going to go back to sharing my screen and turn it over to my colleague, Alicia Chan.
Thank you, Alex, and thank you, Harry. And thank you, everyone, for attending today. We appreciate that you're taking the time to join us. I'm going to go over the segment on e-discovery, and I'm going to start that with a quick overview of some of the rules that govern this area of law, and then move into more practical guidance on how those rules shape what's expected of us in the current work environment. And the rules that I'm citing are from the Federal Rules of Civil Procedure and Evidence, which provide general guidance on what's expected of companies in terms of records preservation and management. However, one of the things to keep in mind is that each case is largely driven by its specific facts, and sometimes rules vary by jurisdiction. Also, much of what we're experiencing is still very new, so the best we can do is rely on legal standards that already exist, stay apprised of legislation and other guidance from trusted sources. And based on the registrations we've received for the program, we anticipate that most of you already have policies in place for records retention, remote work, and bring your own devices. However, as we all know, in recent months, all types of workers have been quickly deployed into remote working environments, so it's critical to re-examine those policies and practices. So starting with the first slide, what records are discoverable in litigation? So those would include records that are in the responding party's possession, custody, or control, includes electronically stored information, which short-sighted ESI here, in various forms, And this may require that if you're the responding party, that you translate the data into a reasonable, usable format. And at the bottom I have, that's the federal rule, if you need to reference it. Alex, could you, thank you. What are the scope and limitations on e-discovery? So what's discoverable? The material and the records you're looking to get would have to be relevant to the claims or defenses, proportional to the needs of the case, and not privileged. So just unpacking, the relevance is pretty straightforward. Proportional to the needs of the case, this really responds to the fact that e-discovery disputes over many years were just tending to eclipse the resolution of substantive issues in a case. So what the courts and the rules have adapted to is to try to balance the burden, the cost of acquiring information against how important the material actually is to the litigation or the case. I have the rules cited there that those basically give more specifics, but I'm just going to give you a cursory overview at this point. So not privileged. Typically what we're just looking at would be attorney-client privilege. There's a work product doctrine, marital privilege, is usually what comes up in cases. Now, the attorney-client privilege and the marital privilege, lots of times we've seen, sometimes people assume that it would just be a communication between an attorney and a client or between spouses, and that's automatically privileged. And that isn't necessarily the case. You have to concentrate on what type of privilege it is. So if it's attorney-client privilege, it really has to be the communication is for the purpose of providing legal advice or receiving legal advice. Lots of times this comes up is if the people communicating are really communicating more about business information as opposed to what's actually privileged. And then moving on to confidentiality. So confidentiality, if you have documents that are confidential, and typically those would be trade secrets, proprietary information, anything that's business sensitive. In litigation, you will have to turn over that, if it's relevant, and it's relevant, proportional, and not privileged, you will have to make those disclosures to your adversary, but you can work with the court and with your adversary to get a protective order in place that would limit those disclosures. And typically what will happen is there'll be a confidentiality designation on any of the records or documents that are exchanged. And sometimes there will be different layers as to what can be shared between parties. So sometimes if the information is particularly confidential, they'll be labeled attorney's eyes only, so only the outside attorneys from the other side can see that. And that's just to avoid situations where if you're in a litigation with one of your competitors, that they actually are going to have information that's out, it goes beyond what's at issue in the litigation and would impact your business in general. So one of the things to guard against, though, with privilege and confidentiality is waiver. So what you have to do is take reasonable measures to protect against waiver. So once you add another party to that conversation with your attorney that doesn't have a common interest with you, you're potentially waiving that privilege. Same with confidentiality. So you need to take reasonable measures, as Harry was discussing he was discussing more in terms of data privacy and data security. Here it's not waiving those privileges, not waiving the confidentiality. And the other concern there is it might not just be that one record that you shared. You actually sometimes will waive the whole subject matter of that. Now that's something that will be disputed in litigation, but you need to be aware of it and take protective measures. And sometimes protective orders, people will include clawback provisions. So if there is an inadvertent waiver, that there are provisions so the parties can deal with how to deal with that. Next slide, please. So what if your company fails to preserve ESI? So this rule 37E was developed to address that. There was a disconnect with some of the courts. So the rules are in place to make sure that it's addressed equitably. Sanctions may be imposed when a party fails to take reasonable steps to preserve relevant records in anticipation or conduct of litigation. and records can't be replaced or restored through additional discovery. The sanctions are going to be more severe, or they can be more severe, if there's a determination that there was an intent to deprive uh, your adversary of the documents. And those sanctions, as I said, are severe, and they can include dismissal of the case or default judgment. They can include monetary sanctions as well. But even where the conduct's negligent, sanctions can still be very significant. So one of the things I wanted to unpack is intent to deprive. It's not just that it's an intent to have not preserve the documents. It's an intent that you wanted to make sure no one saw those, or that no one had access to them at a certain point in time. And typically in litigation, it's difficult to prove intent, but it can be gleaned from circumstantial evidence. So if there's a selective preservation and destruction of records, that might be circumstantial evidence of intent, or might be deemed it. Doesn't necessarily mean it will be. Also, if there's stonewalling, if concerns arise about, well, why are these documents missing, or why are these records no longer there? If it's better always to, we all recognize that mistakes are made, and if they are, it's better to investigate, address them, and try to fix it. We have a litigation that we're involved in that's where this is one of the major concerns, is that our adversary really just didn't do its proper investigation, and then when they were called on it, they didn't move along, and they basically stonewalled and just created more of a mess. Now we're in the process of unraveling that with the court. So there's more to be determined there. Note at the end is that 37E is really relates to sanctions, but there are other rules that might be implicated. So for example, there's rules that govern withholding records, falsifying records, certifying that you've provided complete set of records and you haven't, disobeying a court order concerning discovery, or even offering, as we've seen in some cases, offering perjured testimony that contradicts what's found in records that are found in other locations. And another thing to note is that some states also have independent causes of action for spoliation of evidence. Next slide, please. So when does your company have a legal duty to preserve ESI? So this is the rule that we had just discussed in the last slide, talked about anticipation or conduct of litigation. And this tends to be a moving target in a lot of cases, and there's a lot of disputes because it's going to be very factually based. But you're anticipating litigation as either the initiator or the target, so either as the plaintiff or defendant. Again, it's fact specific, varies by jurisdiction, but it's a reasonable objective standard. So when would a reasonable person have anticipated litigation? And it's not just the mere possibility of litigation. There really has to be a credible probability of becoming involved in litigation. We do recommend involving counsel by at least this point, once you're anticipating litigation, because we're going to be there to help you figure out what your best next steps should be. What does your company need to do to preserve ESI? So the gold standard is pretty much litigation hold. Probably most of you are aware of that. It would be a notice to the records custodians to preserve relevant records, but it's not just a blanket statement, okay, everyone save everything, because you really also have to make sure that if you have routine records destruction or modification programs in place, that those are going to be suspended, at least for the records that are relevant, what you've deemed relevant to litigation. So this doesn't require that everything be preserved, but when deciding what might be relevant, generally it's better to be a little bit more inclusive. And again, counsel will help guide you in that regard. Put your litigation hold in writing. That's just one of the best practices, and record your preservation efforts, because many times this is going to become a main issue in litigation. Make sure that the litigation hold is effectively communicated to any of the people who have access or storing your relevant records. So as we'll discuss a little later, that's your employees, that might be your vendors, that might be contractors, or even your cloud service providers. So you need to really know where all your records are. again, involve counsel in the process, including when to lift the hold. Now, there's so much to unpack here, so this is why I've referenced the Sedona Conference here. Sedona Conference is a not-for-profit organization. It's comprised of legal scholars, including judges and experts in various fields. One of their primary focuses is on e-discovery issues. And they have numerous white papers on their website. You can access them free of charge. So I have a couple referenced here. One's commentary on defensible disposition, and the other is a jumpstart outline. The jumpstart outline is a very good checklist if you need to try to figure out and unpack what records do I actually have. That's a very good starting point. It hasn't been updated since 2016, but it's still very comprehensive. But as anything in this area, as technology is advancing, it isn't going to be a static document, but it is a good, as it's called, a jumpstart outline. So it's a good launching off point. Next slide, please. So here I have some examples of where relevant data may reside. I'm not going to read the right-hand side, but that just gives you an idea of how much information is potentially out there and where it might be stored. But it's not just knowing where the data resides, but it's also the functionality of the resources, including how and whether and to what extent you can actually identify, access, and recover relevant data in a usable format. Again, going back to that first slide, many times it's just going to be burdensome to be able to not only identify and access, but recover it. So that's where proportionality will come into play in the litigation. But these are just certain things that you should be aware of. As we're looking at this, lots of disputes concentrate on metadata, which is information that isn't necessarily apparent from the face of the document, but can be, depending on what's at issue in the case, can be very material to what's going on. The other thing that I just wanted to point out, there's a lot to point out, but when I had looked at it before too, it talks about digital copiers. So even your printers and copiers, sometimes the information's saved in there. So it's important to know how that is, what technology you have, how people are using technology, and just keeping track of it all. Next slide, please. So some takeaways. Records that your employees are creating while working remotely may be discoverable. So you probably anticipated that. And it's not just the employees, as I mentioned before. Maybe it's anyone you might have some control over. So it's partners, contractors, vendors, cloud service providers. So you should monitor any changes in terms of service with cloud service providers. You should also consider, when you have contracts with these folks, how you're going to incorporate what you want in terms of their responsibility and how they're going to respond to your requests in terms of having to preserve and identify the information. The other step would be to develop and implement a clear and defensible records retention and deletion policy, and revisit it regularly. As I discussed earlier, I expect most of you have a records retention policy, but now is a good time to revisit it because lots has changed. And with people being deployed very quickly to a remote workforce, you need to know what your employees and your vendors, how they're accommodating with the work that they need to do. If possible, limit use of personal devices and use good cybersecurity practices to protect your sensitive data. Implement a litigation hold when litigation is reasonably anticipated, and use but don't overuse confidential and privileged designations so that documents and records can be reasonably identified. So many times what I found in practice is, and it's useful because it highlights where people think documents are confidential or privileged, but if you overuse it and everything's labeled that way, it slows down the process. And then again, involve counsel and relevant communications when you're at the point where you're anticipating litigation. It's just, if you could do it, it's sound policy. And next slide, please. Okay, application of information governance in the practice of e-discovery. I think Harry referred to his as more of these conceptual as foundational. it's easy to get overwhelmed with all the specifics. So sometimes you just need to ground yourself in the basics. So the best practices are going to be diligent, be reasonable, and consistent when handling records disposition and litigation holds. And the other foundational old adage is knowledge is power. So the better you know what you have, the existence of records, the format, the storage, how it's organized, and to what extent it's accessible, or how readily it's accessible, the better positioned and equipped you'll be to effectively implement your litigation hold. And not just litigation hold, but every step in the e-discovery process, because it'll help you wield more control of any e-discovery plan that you ultimately enter in the litigation, and it will minimize your costs for identifying, collecting, reviewing, and ultimately producing the ESI. You really want to drive the conversations about your e-discovery plan and how it'll unfold, and you're going to be better positioned to do that if you can convey to your adversary and to the court that you can do that effectively. Sometimes if you can't do that, courts will decide, look, we're just going to pick some dates and we're just going to give you some word searches to run. Hopefully the parties can agree upon that. But usually what it ends up being is you're over collecting information. So, and sometimes that'll be the next step, but at least if you can find information that's going to satisfy your adversary that you gave them it's a process that's revisited over time as well. It depends on what's at issue in the case and how well documents are recovered. But it's something to consider because all of these, what you know is going to help you minimize cost overall. Applying lessons. So now we're at the applying lessons learned section. First lesson, understand what records your remote employees and other records custodians are creating, where they reside, whether and how they're being preserved, and how to access them. So I know I'm repeating myself, but these are things we want to reinforce. So here, refer to the Sedona Conference Jumpstart Outline as a guide. Should consider security issues as well as preserving confidentiality and privileged status of certain documents. So for example, if you're in the home work setting, you need to really make sure that your employees understand how to preserve and not waive privileges and confidential information. And as Harry had discussed, it's going to be similar to how you're securing your data. It's going to be trying to avoid sharing devices if you can, having your own separate passwords, even if it's paper documents, avoid leaving them out. I mean, you never know how aggressive you're going to have on the other side of an adversary, and you just want to be more protective to the extent you can. You want to take, again, reasonable steps to preserve. And one of the other things you should consider is discussing with your employees what they may need to better facilitate remote work while remaining compliant with whatever policies that you implement. Sometimes it's, an employee, they have a laptop, but they get a lot of eye strain. They want to use their home computer because they have a bigger screen, they have a bigger monitor. If it's in your budgets, it's something that should be discussed. How can we help you get to the point so everybody can be compliant? Next slide, please. Avoid blurring the lines between business and personal space. So develop clear policies to guide your workforce. Send them reminders about what your expectations are and the consequences for non-compliance. Remind them that they really do need to keep business and personal matter accounts separate to avoid their own devices potentially becoming targets for discovery searches and increased litigation costs, because now you might have information from multiple sources. It might be duplicative, but while in e-discovery there's many measures that you could take to technology that can deduplicate information. If it's on different systems, it's not necessarily going to be as functional. And take care not to mix personal and business discussions in email threads. I've seen this many times, and it happens, especially when people are a little bit more relaxed, or even when they're under certain pressures. And right now, that's sort of where we are in terms of you're in a different environment than your workstation, your typical workstation. You have different pressures. So people will sometimes slip a snarky email into a thread, and it might not be damaging, but if you don't want somebody to see it in litigation, best just to keep them separate, because there really isn't a way as an attorney looking through this stuff, you're able to redact out and say, well, we really didn't like what this person said here. It's just going to get turned over in litigation, unless, if it's relevant, if it's within a relevant email thread, it's likely going to get out there. Next slide, please. Adapting your policies to new work environments. So again, it's the working from home, and it's also working in shared spaces and with shared devices. So again, revisit your policies. How are people using their personal equipment, and how are they sharing devices for work? Are employees aware of how that policy impacts their remote work? It's important to continue to have the conversations, because it's just reminders, not daily reminders, but just getting in touch with your employees. You're going to be getting in touch with them in general, just making sure things are working out. Now, this doesn't even just only include electronically stored information, because you may have employees printing a lot at home, and you want to make sure that if you're returning to work, they can bring those boxes and they can shred them at work, or just so they know that it's not going to be mixed in. Most of them aren't going to be mixing in recycling, but you never know. You need people to just send reminders and make sure people are clear on what's expected of them. One of the other things you might want to consider is policies to periodically offload data to company databases, especially if they're using personal devices, and so that they delete them off their personal devices. But again, we had talked about metadata before. You have to exercise caution where that's relevant. So for example, if there's information about the timing that a document was created, and that might ultimately be relevant to a case, you need to be careful. So you want to revisit that and be more attentive to that if your preservation obligation has been triggered by anticipating litigation. Next slide, please. Keep pace with technology. So new types of records are being created as we move further away from the traditional workspace. So you need to know what they are, how where they reside, for how long, how do they operate. Are documents being shared through company-approved platforms? Do you have access to employee passwords that may be needed to access them? Harry had mentioned Dropbox before. I know Dropbox has an offering that you don't get to store as much data, but it's free. So sometimes if you're at that limit, people will open their own individual accounts, but if you don't have access to the information, you don't have your employees' passwords, that could be problematic. So do current policies identify and address how the new technology should and should not be used? Again, it's revisiting in the context of not just COVID-19, but how people are adapting to it, and just adapting to technology in general, because we're using new types of technology. And have employees been properly informed and understand their respective responsibilities? Next slide, please. So just by way of example, video conferencing. Video conferences has been around for a long time, but now so many more people are using it, and there's so many more platforms from which you can use it. So do you and your employees understand how those systems work? For example, what are the default settings? What are the security settings? What are the control settings? Do you want these recorded? Now, it's an option, but doesn't necessarily mean you need to, because most of the time, well, many instances, the Zoom conferences are replacing what would normally just be like a conference around a table. So if you wouldn't typically record that, you have to consider, well, is there a reason why I would be recording this? But you also need to be clear on who can do the recording, what's being recording. Are chats that pop up, are those being recording? And it's not always the host that might be recording. You have to make sure, well, how can I control those settings? And if someone's sitting in a room in some other location, do I know that they don't have some other mechanism for recording this? So you might want to start out with a statement that you don't expect it to be recorded. And then our wiretap, if it is being recorded, our wiretapping law is implicated. So those vary by jurisdiction too. Sometimes it's just one person to the conversation has to be aware that it's being recorded, whereas others it might be everybody or multiple people. What measures are in place to facilitate identification and preservation of privilege or confidential communications? Now, if you're having conversations or communications on video conferencing, it isn't so easy to tag what's privileged. So you might want to consider agendas or in titles, just making it clear in that video conference that you're talking about privileged or confidential information. If you're sharing documents through that, make sure that they're labeled as such. You might want to not have a meeting that discusses 6 different topics if one of them is strictly confidential. You might want to lock that down, that meeting, into a separate conference. And how are you going to find this how are you going to find this information later if you do decide to preserve it? And then if you do, what are the associated costs of storage, and as well as subsequently accessing that information, identifying it, and reviewing it? Next slide, please. Anticipated changing and potentially unstable workforce. So this is sometimes referred to as offboarding employees. So you have to anticipate that you may need to preserve or recover records from an employee who has left abruptly or under less than ideal circumstances. For example, unfortunately, we're experienced many layoffs and sickness. Changing workstations. So how are you handling decommissioning, upgrading, reformatting, recycling of computers and other devices where records might be stored? What about changing administrative rights? So sometimes people are, when they're working remotely and just in order to adapt to what's changing around them, are you giving employees more administrative rights than they normally would have had? And when you're bringing them back to the traditional workplace, do you want to keep those or do you need to change those? Same thing with administrative rights as to employees that may no longer be working with you. You need to make sure that your information is secure. Reliance on outsourcing and vetting vendors. So what are your policies? What is your agreement with them regarding data privacy and protection and preserving confidential information? Next slide. So be attentive to how the new and expanded work environments can lead to increased discovery requirements and costs. So if you have more records in different places, locating and recovering those records from sources is going to tend to be more costly. Reviewing records, like I had mentioned, like video conferencing, will be more time consuming. In other cases, we've had where you can make transcripts of it, so it's easier to locate information or identify what's in there instead of having someone attorney review in real time. And there's technology assisted review measures in terms of methods that e-discovery to help minimize costs. But so this is what I had to talk about before. Really, you might want to consider keeping agendas or conducting separate conferences, keeping them discrete so you can readily isolate and locate this information if it's relevant to a litigation. Now, recovering data from chat and other messaging apps can also be timely and time-consuming and costly. There's, and it doesn't come up so much, it really hasn't been a reaction to the COVID crisis, but more data security, ephemeral messaging, where there's 2 components to that, where it's the automated disposition of the messaging. So it's not just me, I can delete my own emails. They're going to look more like texts, but where both the sender and the recipient message at some point in time will be destroyed. So one of the things to keep in mind, though, is that if you're reasonably anticipating litigation, you really need to know how that technology works, because you might need to, if it's relevant, you might need to discontinue that practice. And it's going to look particularly bad if you start to use ephemeral messaging after litigation after you've anticipated litigation. And there was a recent case on that called We Ride that came out of Northern District of California a couple months ago on that. Next slide. So the last slide, actually. So just to take away too is be thoughtful about the substantive and the potentially discoverable records that you may be creating during the pandemic. So, things that we're creating now and developing back to work policies, including surveys that you might be conducting, um, protocols and guidelines for the new work environment, and risk assessments, including drafts. Now, I'm not saying that these aren't things that you shouldn't should be doing. They are. Just be attentive to not blurring the lines, being if you feel that you need an attorney involved, or you think you need some of these conversations protected by attorney-client privilege, involve them. Updated records of retention, destruction plans, decisions regarding employee retention and layoffs, and records relating to crisis funding, PPP applications, and the use of those funds. And I think that is the last of my slides, but yep, there we go. Thank you all so much. I'm going to turn it back to Alex.
All right, thank you, Alicia. We're just about at an hour. We try to save a little bit of time for a few questions, and we'll go slightly over just so we can hit a couple more high points. First, I want to say thanks to both Alicia and to Harry for giving us an excellent presentation with a lot of actionable material that we can bring forward and use as business leaders. Obviously, both of these subject areas are quite large in and of themselves. So we've tried to focus on the considerations for the current time, right? The COVID-19 issues. And, regarding that, I think I have a question for Harry. Harry, can you tell us, has Atlantic seen from its customers that they're starting to provide or asked to provide additional hardware support and put those into the hands of people who are working from home? And is that something that you're recommending to your customers?
Oh, absolutely. As we talked about, whenever possible, it's better that employees are given equipment to use. So when this COVID first started, we spent considerable time providing new hardware, laptops and tablets and PCs for our customers to give to employees, because those devices were a lot more secure and they were basically dedicated to the office work. And again, not being used for, the whole family for toggling between all their social media sites, which in itself creates a major point of inflection for the bad guys to get in. So absolutely, it was a big piece of what we were doing during the first month and a half.
Right. Another question, this one's for Alicia. You mentioned a little bit about blurring the lines between personal and work-related equipment. So just to make it fairly concrete, if a business has an employee who's routinely switching over to their personal computer to do work projects, maybe even a computer that she shares with her entire family, is it possible that that computer would need to be examined as part of a lawsuit?
Well, it depends what you're using it for, and it depends on, that is the risk, and so that's why we would recommend that you try to keep it separate. But it's going to be, well, is the information actually going to be relevant? And that's why I had mentioned the offboarding documents. But you got to be careful about what you're offboarding in terms of. So one of the slides talked about taking the information off the computer and making sure you regularly save it back onto your work computer.
Right.
But make sure in the process you're not deleting information, especially, your obligation to preserve really is only triggered when there's anticipation of litigation, unless actually, as a caveat to what I've talked about before, is, there are other regulations. So I'm talking litigation context and what the rules cover, but you might be in a regulated industry. So in those instances, you're going to have to even be more careful and be aware of what's expected of you. But yes, for instance, I remember being at a home and school association meeting, and they wanted to have a budget for the treasurer to have a separate laptop because they've heard from other schools that someone had raised an issue about how funds were being spent, and you have an aggressive adversary, they're going to want to go after, okay, well, let me go after everything. Not everything on your computer has to be within reason, but people don't want to expose themselves to that. So I know, sorry, that's a long answer, but it depends.
Yeah,
Depends
no,
on
great
what
answer.
you're using it for.
Great answer. Another question, Harry. I'll just sort of bring in some of our own experience as a law firm. Obviously, we have some good policies and some good support where every day normally we would or periodically when everybody comes to the office, plugs their laptop into the network, we would get automatically distributed automatic updates, really without any user intervention. We found that once we all started working from home, that we had to manually initiate those. And I'm wondering if that's a common circumstance that you've seen with your clients.
Yeah, it's very common to see that. Not so much with our clients because all of our clients, we basically have a managed services system that no matter where the devices are, as long as they're connected to the internet, they automatically get managed and monitored. So they're automatically patched, the viruses are automatically updated. And, we basically can give the control and, I guess oversight to them as much as the customer wants on them. So to that point, obviously, is that the challenge was that a lot of people who are using their home devices or going home, that they now became outside of that management, perimeter, and all bets are off because you no longer knew the status of them. So that's why it's also important to make sure that, the technical team that maybe the firm has or the customers have, they can do that. If not, we ensure that it's happening for all those reasons. Plus, we certainly want to protect ourselves for our customers in that we want to prevent them from having problems so it doesn't cause us more work, obviously. But the end game is to protect everybody continually and being able to monitor it.
Right. All right. We're about near the end. I want to conclude with a final vignette and a final thought that I think will tie together some of the threads that have been brought out today, and that's that this current COVID-19 situation reminds me a great deal of another major disaster that businesses faced much earlier in my legal career, which is 9/11. And after September 11th, companies discovered that um, business continuity was a problem that they had not completely solved or had not solved to the degree that they would have liked. And many of them, particularly large companies, found that they had very well considered, very well crafted business continuity plans, but they'd been developed and then stuffed in a drawer and nobody thought about them until after a disaster happened. And then what happened was those plans really were not put into action and cost them a lot of time and a lot of money. And I think COVID-19 is a little bit like that, with an important difference that we've alluded to today during the presentation, which is that the problems that we're having right now, Harry used the word asymptomatic, and that seems to me to be a good phrase, right? So right now you may be having problems. You don't realize it because the disaster hasn't happened, but you have workers who are working from home who are exposing you to e-discovery risks and to cybersecurity risks that you just don't fully appreciate and might not fully appreciate until after a disaster strikes, like a ransomware attack or like some negative results in litigation, or when you go search for important records and you can't find them. So it takes just a little bit of additional initiative for business leaders to dig into what's going on, figure out how their environment has changed and is changing, and make sure that what they're doing matches up with what they expect their employees to be doing and protect their companies against these types of losses. Obviously, our hope in bringing this material today is that each of you will go back to your organizations and seize the opportunity to think about these risks in an organized way and to hopefully head off at the pass these cyber security and e-discovery risks that you face. And if you do that, obviously, not only you prevent disaster, but hopefully, um, find some other benefits as well, and that'll put you ahead of your competition and better position you in your respective marketplaces for long-term success. So again, we've had everybody's email addresses up on the screen. I want to thank Harry and Atlantic Tomorrow's office for helping us put this together. I think it's been very useful, and we really do encourage everybody to reach out to us after the presentation with questions that they might have. The contact information is up there on the screen. We're easy to find, and thanks everyone for their time today. Much appreciated.
Thank you.